Thank you, Madam Chair. Let me begin by asking unanimous consent to enter into the record a letter published today by the Reform Government Surveillance Coalition.
Without objection, thank you.
Madam Chairman, the Reform Government Surveillance Coalition is made up of leading American companies, AOL, LinkedIn, Dropbox, Microsoft, Twitter, Facebook, Google, and Yahoo. And I think the important sentence in their letter is, in the next few weeks, the Senate has the opportunity to demonstrate leadership and pass a version of the USA Freedom Act that would help restore the confidence of Internet users here and around the world while keeping citizens safe. The coalition then goes on to express real concerns with the House bill and urges us in the Senate to make some significant changes to the House bill. So in that spirit, I want to make an initial set of comments, and then, of course, I have questions for the panel. On January 17th, the President ordered a transition away from the bulk collection of phone records. I share this goal with the President, and I applauded his intention at the time. He also stated that it, quote, is not enough for leaders to say, trust us, for history has too many examples when that trust has been breached. Our system of government depends on the law to constrain those in power, end of quote. I agree that we must depend on the law to constrain potential future abuses of government surveillance. But I believe the House-passed bill, the topic of our hearing today, falls short of this goal and is not the true reform I've demanded and many other Americans have for years. In addition to my concerns that the House-passed bill omits many of the surveillance reforms included in the original USA Freedom Act, the Section 215 language in the House-passed bill describing the specific selection term used to secretly collect records is vague enough to still allow the collection of mass information. I believe it is not this administration's intent to interpret the language so broadly, but the NSA has shown time and time again it will seize on any wiggle room in the law, and there's plenty of that in this bill. So, Mr. Cole, let me ask you, even if it is not the intent of this administration or even of this Congress, what would stop the FISA court from interpreting the specific selection term very broadly, should the government ask it to do so?
Well, I think a lot of what would prohibit that is the legislative history, the statements of intent, the legislative history that we're creating here today by making clear and unambiguous statements that this is intended to stop bulk collection, and that what we're focusing on is some focused, tailored inquiries that will depend on the facts and circumstances, and it's impossible to predict all of them ahead of time, but to make sure that we do have focused inquiries and focused collection of information for our investigations. So I think a lot of that is going to come from both the language of the statute, and if there's improvements that people want to suggest, we're happy to work with them on them, but we think the language does it by using terms like specific and identifiers and things of that nature to make it not the indiscriminate bulk collection that had been going on before. And I think also just the reports that have come out of the House, the statements that are being made both by you senators in the course of your comments and by the witnesses that come before you as making up the legislative history, those would constrain it. And I think in addition, if there were an interpretation by the FISA court that it is very broad, that would be a novel and significant order and opinion and would be given to the United States Congress, given to the Senate, and the Senate would then have an opportunity to pass additional legislation to rein it back in. But I would be very, very surprised to see it go in that direction based on the language that's here and the legislative history.
Well, we do have a moment in time where we have to get this right, and with all due respect, I don't remember the FISA court showing a great deal of restraint in the past. But I want to move to my next question, if I could. The current court-approved order for Section 215 bulk collection expires on June 20th. That's not a long time from now. So in the absence of agreement in Congress on a surveillance reform bill in the next 2 weeks, I assume that the administration will ask the FISA court for another 90-day extension. That's disappointing. I believe the administration has the tools it needs to keep Americans safe while also protecting our constitutional privacy rights. So, Mr. Cole, back to you again. Has the administration looked at what can be done to utilize existing authorities such as regular FISA orders and national security letters, if only on an interim basis, to end bulk collection now? Doesn't it make sense for the administration to proactively pursue options, other options today to end bulk collection even as Congress does its work?
No final decision has been made on the renewal, but to answer the specific question, Senator, you don't get all of the features under the existing authorities that you have under the current FISA order that exists or under H.R. 3361. You don't get the two hops. You don't get the prospective production of records that can come. You don't get the time period that's given by the statute, the 180 days, to try and transition into the new type of system and formatting that the phone companies and providers will have to do. So there's a number of features that we don't have today and wouldn't have today without the current FISA order. As the President had said on the 17th of January, this is important information, but we think we have found a way to collect the kinds of information we need to substitute it without bulk collection. But without the structure we have in 3361, we don't have that tool.
My sense, if I could be a bit contrarian, is that the FISA court has expansively interpreted the Patriot Act to allow the collection of millions of Americans' phone records. And if you came to them with a more narrowly drawn interpretation of the law as it now exists, without requiring further congressional office action, that they would positively respond. Have you made any such requests? Have you engaged with the court on those questions?
We have, to my knowledge, not engaged with the court on those questions. We have a judicially tried and tested method here. As the chairman had pointed out, 37 times the court has approved this. Other courts have approved this as well. We're a little reluctant to start going into some other type of legal regimen that has not been tested, that has not been approved by the courts. We'd rather go the legislative route, where the United States Congress and both houses have looked at it, have deliberated, and have decided to pass it. So we think that our choices at this point really come down to what has been approved by the courts over a number of years, the new legislation, or else not having the tools we need at all.
Madam Chair, my time's expired. I want to thank the panel for being here today. As you can imagine, I have another hour's worth of questions. I will extend a number of them to you all for the record.
Thank you, Senator.